internet. Será que isso representou apenas uma troca de canal entre o anunciante e o consumidor? Seguramente não. A propaganda online tem características muito distintas da propaganda no rádio e na televisão, embora ainda haja lugar para mensagens publicitárias convencionais, como as que há nos jornais online e nos programas de rádio e televisão de formato convencional, apesar de veiculados pela internet. Mas as formas de anunciar produtos na internet mais comuns são interativas, e se quisermos achar-lhes um antecessor, elas se parecem mais com os programas de vendas diretas que se tornaram comuns anos atrás com a chegada de TV a cabo. Mas aqueles anúncios eram longuíssimos. Se o estímulo à compra por impulso caracteriza as duas modalidades de publicidade, a modalidade contemporânea, na internet, é mais rápida, mais interativa e, em geral, mais comparativa com os produtos concorrentes. Ela também é mais embasada nos dados dos consumidores colhidos de diferentes formas pelos sites que comercializam anúncios. E quase sempre chega sem ser chamada, de uma maneira ainda mais impertinente do que a cuidadosamente programada pelos canais de TV aberta. Assisti-la é o preço que pagamos para termos acesso a conteúdos que nos interessam, sem pagarmos assinaturas ou ingressos. Essa nova publicidade impõe, certamente, novas questões e novos desafios. Das formas éticas de se anunciar, com o devido respeito pela imagem e demais direitos associados aos produtos concorrentes, à concorrência desleal. Do uso autorizado dos dados do cliente para oferecer-lhe anúncios de produtos que lhe interessam, ao abuso e à invasão de sua privacidade, de sua capacidade de apresentar os produtos sem irritar nem cansar os usuários. E, claro, da viabilidade de se garantir os direitos de propriedade intelectual aos criadores de formas mais éticas, efetivas e agradáveis de se fazer anúncios digitais. Este é o universo do que veremos discutir nesse painel.
Introduced, who is an associate litigation counsel at Google. She has a degree from the Catholic University of São Paulo and also a degree from the Mackenzie University. Dr. Eduardo Azumanishi, who is a judge of the São Paulo Court of Justice since 2015. He's part of the corporate chamber, and she also has experience in law firms and especially in the corporate and fiscal area. He has a degree from the Catholic University of São Paulo in law and also has a degree in business administration from the Getúlio Vargas Foundation in São Paulo. And we have our moderator, Dr. Eduardo Mendonça, who is a constitutional law professor at the University Center in Brasilia. He coordinates the Center for Constitutional Studies. He has a doctorate degree from the Federal University of Rio de Janeiro, and he is also a practicing lawyer. Today we have a very important topic to discuss, which is online advertising, practical and legal challenges of the new communication reality. We are going to talk about the current world and how advertising is taking place in this world. We are going to start with Dr. Camila Rosa, who is going to explain how Google, as a reference company in innovation, is acting in this environment. So you have the floor, Dr. Camila. Good morning to all of you. Thank you, ABPI, for this invitation to be here. It's an honor. It's also a responsibility to address you all. I would like to thank Dr. Eduardo and Dr. Nishi. They are They are models to me. They are people from whom I learn significantly. So I'm very happy to be here, and I'm going to start with a video.
The most human trait is to want to know why. And in a year that tested everyone around the world, why was searched more than ever.
The spread of the coronavirus has passed a significant milestone.
And while we didn't find all the answers, we kept asking. Some questions inspired joy, others excitement.
Life in the bubble.
You love me?
Yes.
You love me?
Yes.
You love me?
Yes.
I don't know what an improper fraction is.
Keep all of those distractions out of the way.
We found toilet tissue, y'all.
Oh my God.
Put it on there and start it up for me.
What are y'all doing? It's still March. How many days in March?
Some questions made us cry.
You know, we've been through our ups and been through our downs. I think the most important part is that we all stayed together throughout. I love you guys.
Some made us worry about this spinning rock we call home.
Fires were detected in the Amazon rainforest.
Why were so many lives lost?
Almost 1.5 million people have now died of COVID-19 worldwide.
Why are we still asking the same questions?
George Floyd repeatedly told the officers that he could not breathe.
So why do we still have strength to continue?
I believe in your power. I believe in our power.
Chants of Black Lives Matter echoed from thousands of protesters in cities around the world.
Why are we not defeated?
We have made too much progress, and we are not going back. We are going forward.
Planes are starting to arrive in Beirut, full of international aid.
Firefighters from around the world arriving in California. There are over 100 coronavirus vaccines in development worldwide.
This is one of those times when people look out for one another and have each other's backs.
We kept going for those who showed us the way.
Think about how you would like the world to be for your daughters and granddaughters.
Remember, the struggles along the way are only meant to shape you for your purpose. Press on with pride and press on with purpose.
Why is it that this year showed its worst and we still found ways to triumph?
An incredible feat for Maya Gabeira.
Naomi Osaka, U.S. Open Championship.
Can't let Corona stop you. Can't let quarantine stop you.
So until we get to every answer, we're still searching.
The world has changed. Until March 2020, we were at this point almost always connected. We were looking for information online. We were engaged in online activity. But we can say for sure that since the beginning of the pandemic, this has only been intensified. Our relations, personal and professionals, the way we consume products and services, everything has been almost fully done online. We have today more than 230 million active users in smartphone. E-commerce from 2020 to from 2019 has grown 70%, and this number has been increasing in 2021. What does that mean? It means that we are discovering how to act online more and more. And this is going to be like that. Certain professions that were never considered being done at home, and now they're being done at home, and everybody's doing okay. So what does that mean for technology? It means that more and more we have to focus on our user, on what we have to offer, and offer the best tool and the best service pursuant to the needs of the user. Talking about Google specifically, what is our mission? It is to organize information in the world, making them available and useful to the world. This is the mission. So what matters for Google is that when you do a search, you find not only a company, but you find information on how to get there. What about traffic? What is the best time to leave? Are there many people queuing for a certain service or product? Photos, videos, reviews, information from other users on a certain company. Everything is done so that users can have the largest number of data and information, and that makes a difference. There's no point only in finding a site, but I have to see how this is going to impact my day. If I know it's the best time to leave home and avoid traffic, I can spend time at home with my kids, or I can do something else. So this is the beauty of the Google tools. I'm very enthusiastic about tool. I've been working with them for over 10 years, and I am very fond of all the products and services that are offered because they do make a difference in the life of users. All right, but when we talk about online advertising, and we have to ask ourselves, how can we use the tools offered by Google to leverage our business? We have Google Ads. Google Ads is the second tool launched by Google. First we had Search, then Google Ad, and it is our online advertising tool. Let me give you an example. I am a photographer. I'm not a lawyer, I'm a photographer, and I want to place ads. I cannot go to large media. This is very expensive for me. I am a new professional. I'm new in the business. So I go to Google Ads. The first thing that I choose is, where do I want to post my ads? Search, YouTube, Google Shopping, or the other advertising opportunities that exist in apps. I have to decide, and I decide that I want to go to searches because anybody searching for photography will find my services. So my choice was that. But where do I go next? I think about the audience that I want to reach. I want women from 20 to 45 years old. And I also want to focus on Sao Paulo, within 20 kilometers from where I live in Sao Paulo. All that has a goal because the user has this choice of audiences. Why? Because they want to have a particular audience, a particular group of people who will be interested in what he or she has to offer. In traditional media, you are attempting to reach an audience. You say, for example, that a certain show has 25% rating, and so my ad will be worthwhile there. But when you show your ad, what about the people who were watching the show? Are they going to see your ad? Are they going to use this break to get something in the kitchen or do something else, or just not pay any attention to your advertising? So when you talk about traditional media, although they are very useful, they are less assertive than what we offer online. So this is one of the best aspects. You're investing your money in something that indeed is going to bring the desired result. You're going to get to your target audience, someone who's looking for that service, and not just a very large group of people. So I'm going to reach someone who needs photography. And I do not want to reach that person who is looking for photography of foods. No. I go to my target audience. I can choose my audience. I can choose my tool, and I can also choose how much I want to spend. And I'm going to spend an X amount of money, and I do not want to exceed that amount. I choose how much I want to spend, how much can I invest in that services. And by doing so, the tool is going to meet my needs. Why is that so special? Because we can reach small businesses. Again, going back to the pandemic, how many businesses were negatively impacted and people had to start a new business because they lost their job or they lost their business. So I'm starting from scratch. And what do? I can go to Google Ads. I establish a certain amount of money that I am willing to spend, and I can go to a target audience, and that's how the world is going to learn about my service. Fine, so I've done that. What about the results? How do people are going to see that? Someone will come to me and say, listen, Camila, I did hire Google Ads, but I can't see it when I go to Google. But I have to ask, do you often look for photography, or are you just checking to see if your ad is being shown? And if you never look for photography and you're just checking your ad is not going to show, because one of the criteria is the experience of the user. If it's not a recurrent search, maybe your ad is not going to be shown. You're not spending much, you are a beginner, you're not going to see that way. So what are the criteria used by Google for a certain sponsored link to be shown in your search? So there is an amount of money that you're willing to pay in terms of clicks related to your ad. This is taken into consideration. Quality. Quality means the amount of clicks that you expect, how relevant your ad is, and the experience in the destination page. Is your site a good one? It provides information that the consumer needs when they are looking for a service. Is it a cool experience? Your quality rate, if you have a good site, will be higher. This is something else that is taken into consideration. Competition, the context of the search carried out. And within that context, we had location, the device, whether it's a smartphone or a computer, time of the day, other ads, other search results, and certain signs and attributes of the users. All that matters for you to be shown a certain ad according to Google. And why is this all relevant? Because, well, considering me, Camila, lawyer, 32 years old, 2 kids, and I live in Sao Paulo. But what else? What accounts for the fact that an ad is good for me or is not good for me? It matters my context, the moment I'm going through. So it matters that I have kids, such that I do related to kids. What is my daily activity? Everything that I have as consumption. So when you create an ad for a specific public, you're no longer dealing with a standard group. No. It goes well beyond that. You have to know, for example, that person likes Japanese food, tattoo, is worried about eating habits, and all these tools allow us to adjust my ad so that it will be targeted to a user that is looking for that. And again, I go back to Google's mission. It's not only the ad, it's not only the user, you have to connect both. You may say, okay, no, fine, everything you're doing is great, but please show me how it works. So this is a Lego search. I love Lego. And that's what I do in my spare time, when there is some spare time. So my result is going to be different from the ones who are not Lego fans and do not usually search anything about Lego. So what do we see? We have our three first results, which are ads. How do I know they are ads? Because it's written ads, anuncio, ads. And here on the right side, there is a list related to Google Shopping. The shops that sell Lego have given me interesting suggestions and the price. What do I get as a consumer here? I get a lot of information. I know the shops that I have to search. I have the prices. If I want to go directly to the store so that I can see it in my hand, the address, how distant it is from where I live, what is this shop offering me? Are there a lot of people there? Is it a crowded region? In times of a pandemic, we have to worry about that. And this brings to the consumer a choice, the possibility of choosing. I can choose rationally and correctly where I want to go. I'm not going to be misled because information is here available, and this is certainly highly important. Google Ads provides all that to you, and Google aims at giving useful and correct information which will account for the fact that the user will be certain of his or her choices. So that's what I wanted to show you about our tool. I believe they are useful to you, and I'm ready for questions. Thank you, Dr. Camila, for your presentation. It's always very important to understand how technology works, how the different tools and programs work, and how companies are performing right now. But I have a question before I give the floor to Dr. Eduardo Nish. There's a question about Google's vision in terms of competing trademarks. So maybe if you could deal with this question before we give the floor to the next speaker. Certainly, this is a very important topic, especially considering the forum in which we are today. In terms of trademark, this is equally important to Google in addition to the experience of user and the one placing the ad. Now, first, in general, a trademark cannot be used in the text of the ad, which means that Nike cannot have this in the text of my ad. But you may say, okay, I saw your example and I could see Lego there. And this was not the official site, it was the ad. So why does that happen? We are talking about people who are reselling, who are selling a certain product. They are retail sellers. So does that apply to everyone? No, it has to be very clear that it's not Lego selling the product, but someone who is selling for Lego. It is very clear that it's not a Lego store. It is a store that sells such products. They are reselling. And the other point that I would like to highlight is that sometimes we talk about trademark as a unit in my search. And that's what I did. Lego was what I wrote in terms of search. And this is allowed. Why? Because you're using the trademark as a word for your search to find information about that product, service, whatever that trademark is offering to consumers. And therefore, not only it doesn't mean any infringement, but it is actually useful to the consumer because they want to know all information available about that trademark. If I entered Lego, I was given information that was useful to me. Perfect, thank you. I think these additional clarifications are very important so that we can understand the tool as a whole and how it works in terms of IP. So I would like to give the floor to Dr. Eduardo Nishi for his comments, so we can understand how courts are considering technology, how courts are dealing with the challenges. We, from the legal field, we have to anticipate in terms of what is going to happen. But technology also presents many challenges for those who are in the legal field. So it's very interesting. It will be very interesting to see your view in courts and how this is being dealt with. Thank you.
This interpreter can barely hear the speaker, I'm afraid. It is a great opportunity to be here. I'd like to compliment the other speakers and Eduardo Mendonça, who's part of this panel. I would like to thank ABPI for the invitation. The sound of the speaker is too low. It barely allows for interpretation, I'm afraid. I would like to bring the experience of the specialized entrepreneurial chambers in São Paulo. We have 2 chambers that are specialized, and I am a member of the first one. The chambers in São Paulo are the only ones specialized to judge the second-degree issues in the country. And we already have we have had these specialized chambers for more than 15 years with the advent of the new bankruptcy law of 2005. And then we started to add other issues like pre-arbitration conflicts and industrial property. So this is one of the items that we judge in a specialized manner. So we have digital advertising, which can be quite similar to traditional advertising with banners and search and span, direct mail, video ad, links, screens, pop-up ads. These forms of digital advertising, the issues that we have are the same that we have in conventional media, TV, radio, and newspapers. The same protection for material rights with the same elements of analysis are basically used in digital advertising. As to search marketing, there are issues that are different from traditional media in a recurrent fashion. So we were judging cases. Of these 60 cases we judge in that session, there's at least one involving these search tools which are discussed, dealing with the use of brands and competitors as a key word in the search service. And these services of sponsored links are for the hiring of services so that the service providers can advertise their services. And this has been quite an effective mechanism for promoting and doing marketing of services and products. And so the sponsored initiative is to increase online traffic and to increase the exposure of their brand and commercial proposal, and therefore sales and market participation. I will briefly explain about some factors which are, in my view, important to provide context to this discussion. First, strengthening electronic media to the detriment of the traditional ones like TV, radio, and newspapers. So there's the decline of the communication giants and leadership of technology companies that work with information technology and communication. And some of them have been ranked amongst the 10th most valuable around the world. So if you take the 10 most valuable companies around the world, there are these technology companies that deal with information, whereas companies that up to 10 or 15 years ago were traditional are no longer seen. So there was a migration in terms of market revenue and wealth amongst the agents or actors in economy. So there's the emergency of digital marketing, which is a vitally important mechanism for companies in order to disseminate information about their products and services on the web. So this is the main marketplace right now. It's the most visible exchange. The pandemic made it very clear that the marketplace was strengthening, namely companies that sell products made by yourself and by other parties. And they're also amongst the world giants. And here in Brazil, we have the examples of Americanas and Magazine Luiza. They were traditional retailers who have found quite an attractive source of revenue to go digital, even more profitable than their traditional activity. There are also giants that do this marketplace so-called activity that is the intermediation of products and services in a digital fashion. So there's a displacement of income and wealth in traditional economic sectors and physical traditional trade. And when we talk about physical trade, we talk about food, which is something, the interest of which has become greater during the pandemic. These were digital businesses which were allotted quite an increased share of the available revenue for consumption. Values and brands became digital intermediators or go-between. So there is an advantage to those who speak to consumers digitally. The impact on products and services, transportation, is a reality that creates an opportunity for small agents that can compete with the large ones because of the advertising tools today, which are less expensive, they have greater focus than dispersed traditional media which were expensive because they were spread out. And they were like a widespread shot and not a focused one as it is today. The services for free business for model that expose users to advertising is also a new model which can be compared to open air television and radio, which you don't pay to use, but the service is paid for by exposure to advertisers. So there is payment to the service by means of advertising and not by means of the use of the service from the part of users. This new reality also leads to changes in behavior, lifestyle, changes in consumption habits. And there's also the issue of information. There is a change from mass media to segmented media, especially by means of artificial intelligence services. With technology and information, you can talk to millions of people. With artificial intelligence technology, and they send out messages that are focused based on location, as was mentioned before, eating preferences, fashion preferences, political preferences also. Age, so we start having global communication, which is quite encompassing, but with greater personalization in view of artificial intelligence tools. So today there is a lot of information. We have so much information. We have too much information. This is the information era. But this strengthens the need and convenience of the search services. So we live in an era of information and abundance, and these search services are important in order that there can be screening and information customization. By means of these services, you can look for what you need in a quick and objective way, no matter what. The self-service reminds us of the old yellow page service. Maybe some of you don't even know what this is, but yellow pages were a very thick catalog, a thick book, and that was a reference of services basically for users that had telephone lines. So we would receive every year a catalog, a list with subscribers, lists, and yellow pages. Also, the supplement on automobiles in the newspaper was very thick, and now you don't have that anymore. I lived through a time which was a way to show children by parents the importance of culture, to have an encyclopedia at home. So you would have Encyclopedia Britannica, Barça, Connoisseur, or every family used to have that, but you no longer have this. Everything is in the search service. We say, well, let's Google it. And so the verb has been incorporated into everyday language to mean searching for information available on the web. So it's organized information made available in a democratic way that is accessible, perfecting the supply side, which contributes to reducing, which I think is very important on the consumer side, the asymmetry of information provided to consumers. That is, it is easier today, by clicking away in a few seconds, to have 30 or 40 pieces of information about pricing, delivery deadlines, when you did not have that before, or you had it only sparsely. And this has been an improvement and has also displaced business margins of retailers to those who hold this information or organization. And as I see it, has also made some businesses more competitive. Competition becomes clearer. We have to try and obtain a better way of working, which also implies a concentration of corporations, without a doubt. A player concentration. Efficiency is improved, but it also brings about other problems, especially of a competition nature. I shall now, in the next 10 minutes, devote to some legal issues which I believe to be relevant to analyze this topic. Firstly, one has to understand that there is an environment of economic freedom, freedom of competition and of initiative, which is positive. So this is the rule of the environment we are in, and this rule is applied not just to these search services, which in principle enjoy freedom of opening enterprises, to establish criteria for collection, to establish criteria for selection and search according to convenience, because this is an entrepreneurial market activity. This freedom is also enjoyed by the consumer. A consumer can use a service, or if he or she is not happy, may use another one. We always have the idea that there are few players in this market, but there are several. I don't know if it's 44 search services, and each of them are competing away out there. Some of them are becoming specialized, working in niches or in themes or topics. So there is a free market from the point of view of consumer choice, and there's also freedom of economic agents that provide goods and services on the web. So there is a climate of complete freedom, at least in principle, which has to be the rule and not the exception, as always. Now, if we analyze this in the light of the industrial property law, I think that the interpretation technique is works in a contrary fashion, in an opposed fashion, that is based on the exception. The structuring of types and the hypothesis of infringement of the industrial property law typify a crime in penal terms, and the principle of interpretation of
the generating factor has to be applied to a type as pursuant to the legislation. And often the nature of the unlawful acts has to be observed because there's a penal aspect and a civil aspect. And criteria are these defined types that I mentioned, and not an interpretation that leave a more flexible interpretation. And why don't we discuss further the issue of the criminal act? Because it is seen as a minor crime with very light sentences. And also it is related to the injured party. It depends on the willingness of this of the injured party. It is his or her initiative, and very little is said about this issue, but it defines how the law should be construed in applying such devices.
Now, when we talk about this topic, there are two aspects. There's the brand aspect and the unlawful competition aspect. When we talk about the brand aspect or the trademark aspect, I'd like to draw your attention to three clauses, 129 of the Industrial Property Law, 132 and 189. 129 says that the holder has exclusiveness in the Brazilian territory. Exclusive use is assured. So in principle, when you read this clause, this provision, you believe that nobody can touch third-party clauses because exclusive use in Brazil is assured. And some of the sentences are issued based on that. But I believe that this analysis, the reach of the term exclusiveness, first refers to the use as distinctive sign, which is visually perceptive. And then there's Article 122 for distinguishing the product of service. So it has to be analyzed in a systematic manner. I'm not saying analogically or extensively, but rather systematic. And then if we look at Article 122, we see that trademarks are visually perceptive signals and signs. So the exclusive use of the trademark refers not in an absolute fashion, but to the use as distinctive signs of products of services that are visually perceptive. We cannot analyze 129 in isolation. It has to be analyzed in a harmonic and systematic way. So the exclusive use of the trademark refers to distinctive signals. I've already said that actually. So the exclusive use, the prohibition of exclusive use, it's not absolute. It does not cover the use by third parties as a keyword because there is not an exterior use of distinctive signal. When this is not shown, when it does not appear, as I see it, it is not covered by the hypothesis of Article 122. Should there be this impossibility of the use of the trademark for advertising purposes for third parties, there would not be what precedence has already accepted, that is comparative advertising. The possibility of the use of the trademark is there. Otherwise, there would not be this discussion about comparative advertising, which has already been defined as legal should some conditions be preserved, like when there is clarification to the audience and consumer, the public, in an objective way regarding comparative use, when the comparison shows the differences between the two products, and when there is no confusion between products and trademarks. This is common and is also a topic that is pertinent to what we're discussing today. Confusion between competing brands and services should not be allowed for purposes of legal comparative advertising. From the competition point of view, also based on Article 129, as I see it, there is no such typification of trademark infringement. And we also have Article 132, which is a negative command, where the trademark holder cannot stop certain situations. One of them, mentioned by Dr. Camila, regards paragraph 1 of 122, which is they cannot stop dealers and distributors to use distinctive signs and signals. So the trademark can be used, and the trademark holder cannot oppose to that. But the most relevant point in 122 is paragraph 4. The holder cannot stop mention of the trademark in speeches, in scientific, literary publications, or any other kind of publication, provided that there is no commercial connotation and no damage to its distinctive character. So I believe that there is an element here that has been used to claim this, that is, the reasoning goes the other way around. If the legislator talks about the hypothesis of no non-use, if there is a commercial connotation, there is authorization for the trademark holder to limit or stop its use. But we go back to that principle. Here we are establishing what cannot be done, but that doesn't mean to say that what is not there can be done. So there is the interpretation which cannot be admitted in an extensive, inducive way, or even analog way. So this is also a point where I see judgments having judgments based on this fundamental, which in my view should not persist. So from the trademark point of view, I do not see any infringement or typified infringement. What there is in a lawful competition. This is where there can be discussion. Judges believe that this is infringement based in competition and not trademark infringement. And we should read Article 189, which says, or rather before that, I apologize, 189 talks about reproduction and trademark. Here there is no reproduction. Reproduction should also be interpreted as the exteriorization of the trademark, which should not be a criterion for hiring a service. So This is also in 189, and it all goes to say that it seems to me that there is no trademark infringement according to 132, 122, or 189. In unlawful competition, there is more controversy. It says that unlawful competition is there is fraud for deviating for oneself what should have been addressed to another party in terms of clientele. This is where the great controversy lies in the court system, whether there is infringement based on this fraudulent means for attracting to oneself another party's clientele. There is subjectiveness on the legislator as to what is fraudulent means. Fraud in a dictionary reads, it is an ill-fate act meant to fool someone. It is a skillful lie. To lie or to cheat or fool someone else. Professor Venosa also, when speaking to fraud or law, says that it is the use of a shrewd or a lying means to fool someone. There's Article 5 that says unlawful or undue use of a trade name. So when you look at this situation, I believe there is no fraud. Fraud is there when you fool someone. And the distinction between an ad or a sponsored link according to the criterion of the average human being that is the target of this message, this is very well signaled out, and it ends up by mitigating this issue of being fooled or misled. So the user does not go into the competitor's page without making a click. It is offered to him, options and alternatives are offered to him or her, but he or she is not forced into going into a different web page, which would be the hypothesis of being fooled or misled or containing this fraud. As to undue use of the trade name, this is also an open concept. Is it undue use to use keywords? This is an open concept which has been responded by the judge. It is undue to use the competitor's name to provide its offer or alternative, and the search engine helps consumers making more consistent decisions. So I don't see that there is undue use here. Quite the opposite. From the point of view of users, it is a way of better organizing. Users often or sometimes want a right address with the right predefined supplier, but sometimes he or she wants alternatives and options. So I believe that this is a legitimate way of advertising, an honest one. So I think that this is candid and honest. It is a way of providing choices in an honest and candid way. When we talk about subscriber telephone list, part of that was included in a wireline telephone subscription provided by the Telesp, the São Paulo telephone company monopoly. And there were yellow pages, there were sponsored ads and non-sponsored ads. And I could, in yellow pages, I could say, I want to be beside my competitor, which is X. And there was no more choices. It was a monopoly public service. It was a concession given to the state of São Paulo.
And even in situations in which there was no alternative, the consumer had to go to another service. Now the consumer has the capacity to choose a different option. Recently, I met a friend who did not recommend a restaurant close to where we live. And then I met this friend again. He said, I went to that same restaurant, but you said the food was not good. And then he said, well, I have no other choice because it's so close to where I live. No, yes, you do have other options. Where we live, there are many options. So this is just a comparison to this situation. Sometimes you think there is a vicious glitch in the system which prevents you from choosing, but actually you do have this choice. I understand that there is an interpretation that often leads to the conclusion that it is a misleading service when in fact it is not. This is my understanding. And going back to what I said before, the activity of searchers, this is an entrepreneurial activity, and the upgrades and the improvements, this is part of acting in a competitive environment. There is a different rationale. The rationale is that you are providing a service. It's not public, it's private, but you're not charging for that. But what is the counterpart? The counterpart is the ad. So when you talk about something that I compare to the yellow pages, I want to be close to the competitor. But how do you do that? Well, you can have the name of the competitor, but you can define the activity, you can define the neighborhood. So this is one of the criteria, just as we have many others, to choose the keywords that are going to lead, that are going to guide us in the search activity. There is this freedom of having an ad just the way you want, organize your page the way you want. You can have something in the right corner, in the left corner, and decide to exhibit or not the results. Dr. Camila mentioned the criteria which are used, but I do not see this as a requirement. What I mean is, it's not a requirement to explain the mechanism. This is the trade secret. which makes a difference, which is a differential. Very quickly, I don't know if I still have time. I've exhausted my time, I'm being told. So let me mention a few decisions which run counter what I just have said. And I think it's important to highlight that. Judge Barbosa said that it is misleading and confusing for the consumer because the law is always going to be based on the use of exclusivity, as I mentioned before. So there is an over exhibition when you're using the words of the competitors within the same market. This can be seen and has been seen by other judges as such. And there are decisions going back to 2012 by Judge Cunha, who has already retired, and other judges. This one that in particular that I'm considering left in 2016. And even going back to 2008, there are decisions that agree that there is a confusion when that happens. And there is also an issue that we call the parasite activity. But Dr. Tatiana is giving me the time off sign, so I think I will conclude here. I'd like to thank you all for your patience, for your time. Thank you. Thank you, Dr. Nish. Unfortunately, we have to control time so that we can have the opportunity of engaging in debates, and I'll ask Dr. Eduardo to conduct the debate, but I thank you for this brilliant class touching on the fundamental issues and the fundamental questions that represent a challenge and have to be clarified. So construing the law, given the new challenges faced by the industry, brought about by the new technology, this was extremely important. Thank you, and I give the floor to Dr. Mendoza to start the debate. Good morning to all of you. First, I'd like to thank ABPI for this very for this invitation that makes me very happy, and I'm happy to be my colleagues in the panel. It's always very good for a lawyer to hear an appeals court judge and to see how the interpretation in terms of cases in the economic field will require a special reasoning. So I'll try and be very brief in terms of the questions so as to be able to give the floor back to the speakers who have brought such important points, who have given us classes in the matter, as Dr. Tatiana said. Going back to the organization of information, which was mentioned by Dr. Camila, and access to information, which is something which benefits the competition, the consumer, and it improves the market. And Dr. Nish also mentioned that. And taking that into consideration, I'd like to present a question that may bring about a certain controversy when we talk about such criteria. In some places, as Dr. Nishi mentioned, there's this more general idea that the use of a trademark for such end, so the one who is searching will be exposed to the information on competitors that could be unfair competition. Based on my constitutional studies, I see that as the opposite of what has been said. I don't think a trademark has the fundamental right to, in a private environment, in a search environment, which has to present information to the user. So I don't know how we would deny the user the fact that there are other options. And there's a search for a certain trademark, but there is the suggestion of other trademarks. And of course, this could not be a direct system of orienting the user to other trademarks. So just to begin the discussion, I'd like to propose and provoke you to take this lens using this more generic view of unfair competition, which seems to be more intuitive than grounded in norms. But we are given trademarks to block information to the consumer if we were not to allow that. Are we saying, listen, you've built an image and we cannot give the user information on others in a search environment, because that's where the consumer goes for information? Aren't we reversing the very rationale of what has to be given to the consumer? And when we consider comparative law, has this topic been faced and tackled, and how has it been approached, given this idea, or addressing the idea that there is a predatory action when we have several marks offered to the consumer? So Dr. Camila, you can go first. Yes, I would like to go first. Thank you. I fully agree. That's exactly how I think. The idea of trademarks that nobody else can not even mention that trademark, that means a loss to the consumer. And let me give you an example. And an example from the offline world, because when we are discussing the digital worlds, we tend to think that it's more confusing. So let's go to an offline environment. We go to the supermarket and we ask an employee, where do I find the tomato sauce pomarola? When that employee takes you to where the pomarola tomato sauce is, it's not going to be only that the consumer will see. There will be other brands, Elephant or whatever trademark is there exposed. And this is done. It does not characterize unfair competition. Quite the opposite. It's free competition and access to information being given to the consumer. The consumer will be able to compare prices, information, nutritional value, the amount that comes in each jar according to price. This is beneficial to the consumer, and it is exactly what we see when we talk about Google Ads. If you've entered Nike, you're going to see Nike, All Stars, Adidas, and many other trademarks and other sneakers from other competitors. So the consumer has access to more data about what he or she is looking for. And as Dr. Nishi mentioned, often the consumer does not want to see one specific trademark. He or she wants to see what is available for me, what suits my purpose best. And this is comparative advertising. So Google Ads is nothing more than comparative advertising. It does not mean unfair competition. And precisely, if we think about comparative law, this is the discussion that we have to engage in, as long as it does not bring confusion to the consumer. This is a legitimate use of the mark as a word of search. And I've already explained what are the policies at Google. But if you have a search word, and if this is beneficial to the consumer, and if it is made clear to the consumer that these are ads, you don't have only Nike results. You can go to one site, but you know this is not the Nike site. There are indications of sites of other brands. This is positive, this is beneficial, and there are decisions from the European Union. And there's also a case of competitors that try to get an agreement of not using one trend. They agree on preventing the consumer from seeing other brands. But this is not beneficial to the consumer. There are decisions on that because the consumer should have access to all data that will allow he or she to reach a decision. Well, thank you, Dr. Camila. Dr. Nishi, you have the floor. I understand that there is a resistance in recognizing a different rationale or a different market structure. Internet and technology allowed today that David will be able to combat Goliath in a way that is less costly, maybe not in terms of cost per unit, but there's a more focused way of engaging in this fight. So therefore, the rationale has changed. The competition and all the issues related to competition discussed in terms of IP, in fact, it aims at establishing a discipline horizontally among those who are offering their products. But there's another aspect related to consumers, and they are governed by the antitrust law, which aims at correcting market imperfections that may harm the consumer. So when we invoke the unfair competition law, and we are talking about competition among competitors, but this does not meet the situation set forth in the law. So when we talk about improving the legislation, we are talking about a vertical line in which we have consumers and competitors. And in this sense, the tool actually expands the competition. It improves the competition. It turns this competition more effective, more efficient for market relations, given the reduction of the information disparity that exists, given the deficiency in access to information, which is corrected exactly by this mechanism. In talking about the international cases and international decisions on this matter, I was recently in a WIPO meeting, and I asked my Spanish colleagues about it, and they said, we don't even discuss that anymore. And I asked them to send me the decisions. At the time, we were discussing the first cases here in Brazil, and there is a directive from the European Union, it's 89/104, and it talks about it, and it mentions exactly what Dr. Camila said. The holder of a trademark should not allow a similar trademark without the consent of the holder use it in terms of the internet providing services similar to the ones offered by the registered trademark when this advertising does not allow or hardly allows the consumer to determine whether the products come from the holder of the trademark or another company related to this one or to a third party. So there is unlawful use and there is infringement. If the distinction, if the differentiation, which should be perceptible to the usual, to the average user, then it would be an infringement. And this is a decision from the Justice Court, European Union, 2010. So it's been a while. But it's interesting to see, and I was going to mention that there is a precedent that dates back to 100 years ago, when the holder of the trademark invests money and energy to have a good reputation, so as to be protected by the Misappropriation Act. And there is this is in the Associated Press, was published by Associated Press, 1918, almost 100 years ago. And the corporate name means one of the basic attributes of a company, and therefore this should be taken into consideration. Sorry, he's reading the text of the law which we don't have access to, which we don't have access. So this is 100 years ago in the United States. There was no technological context as we have today. So this is basically it. Thank you, Dr. Nishi, for your considerations. And I'm going to give the floor to Dr. Eduardo for the final questions. There are some questions here in the audience. He's going to try and consolidate in one single question so that you can have your final comments. And also we are trying to be within the restrictions of time that have been given us. I'm going to be very straightforward. I will combine what was asked. It was mentioned, there's a convergence, that when the consumer is not induced to a mistake, this mechanism contributes to a better competition, a better competitive environment, giving more information to consumers, allowing more consumers to be in the market, and therefore there would be beneficial to all sides. Let me ask, and maybe Dr. Camila can answer, what happens when there is an unlawful use, or when you detect that there is induction to error? And also a question to both of you. It's been mentioned that this type of advertising on the internet can be more directed. It can reach people who have already an interest on that point. This is very positive, but it also raises concerns in terms of data protection. So along this line, I would like to ask what type this identification of preferences of the user is compatible with our legislation, particularly the law on data protection. So I know these are two difficult questions, but I think it will be interesting. Thank you for this masterclass that you have given us. Dr. Camila, about the first question, again, once the ad is violating our policies, and what are the possibilities? the trademark is using in the text of the ad and also is misleading, the owner of that trademark will be given a questionnaire, will be given a form to be filled, and will provide information, and this will be corrected in our platform. Any ad that is in disagreement with the effective legislation will be removed should the case be proved that it runs counter our policy. In terms of privacy, user data, and this is certainly a very timely topic, I would like to mention that Google wants user to have control, security in our platform. So the first thing that I would like to do is to invite all of you to go to privacy.google. When you go there, you will have information available on how Google control data, which data is stored, how data can be removed. This is about your power as a user in terms of our tools. Another invitation to you is go to myaccount.google. This is your account. So once you're logged in, you will go in the site and you see all information about your account, everything that you've done in terms of your account. If you allow Google to have information on the web, the apps, the location, history, ads, and all that, the user will be able to choose if they are still sharing with the company or if they are not, if some data has been shared but the user has changed his or her mind, this can be done. And thinking about the Data Protection Act, something that I would like to say is, for example, you have an account. So in 2019, we've had 2.7 billion people who access my account to see what data was being shared with Google. In 2020, this went up to 3.2 billion users. So users are doing that. They have the necessary information so that only what they want to share is being shared. These are the pillars to Google. This is very important, and I'd like to invite you to access and see how this is being done. Let me give the floor now to Dr. Nishi so that we can conclude our panel. This is a very interesting question. I was talking to Dr. Camila before we started that probably we are going to have many legal discussions on that, on data protection. I did not know the possibility of limiting, restricting data usage under Google. And I think 99% of people are unaware of that. But it's very interesting to see that as we go along, we are opting for a service that is more or less personalized. So this is the counterpart for the search. If you allow this search, what we have to consider very carefully is how data is being used. And here we do have to carry out an evaluation, because whatever tools can be used for a beneficial purpose can be used negatively as well. And this is going to be a matter of discussion. These technological tools are very important. I'm looking for a paper here that will show an article that indicates that we will no longer engage in searches because the search engine will bring everything once you ask a question. So it's so sophisticated, so much information is involved, personal information, because the search engine will have to understand what you want, taking into account where you are, your preferences, to be able to provide the correct answer. So I foresee an intense discussion, but this is a result of a technological upgrading. The class that Dr. Camila has taught me today is like seeing Disney behind the scenes, because Disney is wonderful, but there is the behind the scene activities that are not seen, and we don't see these details. Actually, they are not details. They are very important tools that we are unaware of. And it's very interesting that they are disclosed so that the user has an opportunity to engage in this trade-off, in this exchange. I am giving you data, but I don't see what I'm getting in return. So these are very difficult relations, and they are all new. Definitely the principle of transparency, the major pillar in this talk is this. I would like to thank all our speakers, our moderator, Dr. Mendoza, Dr. Camila, Dr. Nish. I would like to thank our interpreters and ABPI for organizing this fantastic Congress. And my thanks to the audience. We have to close now, but once again, thank you for your participation. Thank you.